Nobody is talking about the $24.6 billion reason this Supreme Court ruling should scare you. $24.6 billion. That's the size of a merger the government blocked 2 years ago to stop your grocery bill from exploding. 1 week ago, the Supreme Court issued a ruling that could mean the block never happens again for this merger or the next. By the end of this video, you'll understand exactly how those two things connect and why almost nobody is talking about it. The $24.6 billion deal. In October 2022, Kroger agreed to buy Albertsons for $24.6 billion. On paper, that's two grocery chains merging. In reality, it would have created the largest supermarket merger in the United States history, combining nearly 5,000 stores and roughly 700,000 employees under one company. Kroger already owns Fred Meyer, Ralph's, Harris Teeter, King Soopers, and QFC. Albertsons owns Safeway, Vons, Jewel Osco, Acme, and Shaw's. Put them together and one company would have controlled a huge share of the grocery market across dozens of states, going head-to-head only with Walmart and Costco at that scale. The Federal Trade Commission sued to block it in February 2024. Their argument was direct fewer competitors means higher prices for milk, bread, and eggs, and less bargaining power for the workers stocking the shelves. The public reaction was massive. The FTC received over 100,000 public comments on this single merger, an unprecedented number. In December 2024, a federal judge agreed with the FTC, and a separate Washington state court ruled the same way on the same day. Kroger and Albertsons abandoned the deal. Albertsons later sued Kroger for $6 billion, accusing it of not fighting hard enough to save it. Whatever you think about grocery prices, this is what the FTC is designed to do. Step in front of a deal that size before it reaches your receipt. This wasn't a fluke case. Either FTC merger enforcement has repeatedly relied on the same structural fact. Commissioners who can spend months digging into a deal, litigate against companies with far bigger legal budgets, and still say no, without worrying that the no costs them their job. Kroger and Albertsons together spent close to $1 billion trying to push this merger through. The FTC didn't have anywhere near that kind of money behind it. What it had was legal independence, the ability to make the call on the merits and let a court decide, instead of making the call whoever is in the White House wanted. Hold on to that number, $24.6 billion, the firing that unraveled 91 years. To understand what just changed, you need to know about one person, Rebecca Slaughter. Slaughter was a commissioner at the FTC, appointed in 2018. In March 2025, the Trump administration removed her, along with fellow Commissioner Alvaro Bedoya. The termination letter didn't accuse her of any misconduct. It stated only that her continued service was inconsistent with the administration's priorities. That was the entire reason. Slaughter sued, and federal district court sided with her, citing 1935 Supreme Court case called Humphrey's Executor, which held that Congress can protect certain agency commissioners from being fired purely for political disagreement, specifically because their work is supposed to sit outside day-to-day politics. That protection has stood for 91 years. On June 29, 2026, the Supreme Court overturned it. In a 6-3 ruling in Trump versus Slaughter, the court held the FTC commissioners can now be removed by the president at any time for any reason or no reason at all. Chief Justice Roberts wrote that FTC administrators roughly 80 statutes covering nearly every corner of the economy, and that enforcing those laws counts as executive power, not neutral oversight. So, commissioners can't be shielded from removal. The practical result? The FTC is designed by law to have 5 commissioners with no more than 3 from one political party. Right now, it has 2 commissioners. Both are Republican. This already happened to other agencies, and it wasn't quiet. Here's what makes this predictable instead of theoretical. It already played out at 2 other agencies months before the Slaughter ruling. In January 2025, the administration fired NLRB board member Gwen Wilcox and a Labor Board General Counsel without alleging any wrongdoing. The firing left the National Labor Relations Board without enough members to issue legal decisions. The agency that resolved disputes between workers and the employers simply stopped being able to function. Companies including SpaceX and Amazon are among those then 24 that have separately sued the NLRB, arguing its authority itself is unconstitutional. Then, in May 2025, 3 of the 5 commissioners at the Consumer Product Safety Commission, the agency that decides whether toys, appliances, and electronics are safe to sell, were fired the same way. A federal judge ordered them reinstated, citing the same 1935 precedent. The Supreme Court paused that order on an emergency basis while the case continued. Both fights were explicitly framed by the government's own lawyers as building blocks towards the bigger case, the one about the FTC that the court had already agreed to hear. So by that time, Trump versus Slaughter reached the Supreme Court. The Labor Board was already stalled, and that the Product Safety Commission was already short-staffed. The FTC ruling didn't invent this pattern. It made it permanent and extended it to roughly 24 other independent agencies whose protections now sit in the same legal position. One rule for Wall Street, another for your grocery store. Here's the part that should really stop you. On the same day the court stripped FTC commissioners of their protection, it has issued a separate 5-4 ruling in a case called Trump versus Cook. That ruling said that President could not remove Federal Reserve Governor Lisa Cook. The Fed, the majority ruled, is constitutionally distinct from agencies like the FTC. So, the agency that oversees interest rates and the banking system that Wall Street depends on stays independent. The agency that decides whether a $24.6 billion grocery merger goes through does not. Alvaro Bedoya, the commissioner fired alongside Slaughter, pointed to exact this gap. The institution investors rely on kept its shield, while the one standing between corporations and your grocery bill lost it the same week. Justice Sotomayor joined the Kagan and Jackson, dissented from the FTC ruling, arguing the majority discarded nearly a century of precedent and handed the president a degree of removal power over the domestic regulators that has no real historic parallel. 2 rulings issued hours apart by same 9 justices. One protected the institution serving the financial industry. The other stripped protection from the institution serving you. What happens the next time a mega merger lands on the FTC's desk? Now here's where that $24.6 billion number comes back. The Kroger Albertsons block only happened because the commissioners voting to fight it in court knew that it couldn't be fired simply for making that call. This is exact protection the Supreme Court just removed. The next time a merger anywhere near that size lands on the FTC's desk, whoever is chairing the commission will be deciding whether to challenge it while knowing the president can remove them the moment the decision becomes politically inconvenient. Legal experts who have watched the NLRB and CPSC fights point out that this pressure doesn't require an actual phone call telling a commissioner what to decide. The threat of removal is already built into the job before the vote is ever taken. That's not a hypothetical. It's already happened at the NLRB, where board members' fear of removal froze the agency's ability to function at all. The same structure risk now sits over every future FTC decision, including the next mega merger review. Congress could, in theory, pass new legislation restoring for cause protection to agencies like the FTC. But Congress created these protections in first place specifically so agencies wouldn't need to depend on whichever party currently controls the House, the Senate, and the White House. Asking the same politically controlled Congress to build an independence the court just said the Constitution doesn't require is a very different proposition than the independence that existed for the last 91 years. So the legal cost of this ruling isn't an abstract legal question about separation of powers. It's every future $24.6 billion decision and whether the person making that call is protected enough to say no. $24.6 billion was blocked once, specifically because the FTC could act without fear of political retaliation. Nobody is talking about whether the next deal that size gets the same scrutiny or gets waved through because saying no now comes with a personal cost to whoever says it. This ruling is not that old. The NLRB and CPSC firings that came before it are already documented, litigated, already real. This isn't speculation about what could happen. It's a pattern that's already playing out, and the FTC just became the latest agency pulled into it. If this is the first time you're hearing this connection, that's exactly the point. Drop a comment and tell me what you think happens the next time a merger that size comes across the FTC's desk.